So just a few words about me. I was born in Krakow, but moved to Warsaw because Warsaw is a better place for lawyers. So this is the first point I'd like to raise. Okay. So you can shoot me now. So I was born in Krakow, but 7 years ago I moved to Warsaw. I was working as an in-house lawyer for Agora, the biggest Polish media company, publishing Gazeta Wyborcza and Gazeta.pl and so on, so on, so on. Then I moved to MTV. I was in-house for MTV Networks, the very famous television, famous from having music on the channels, but right now it's not music. Right now it's Jersey Shore and Mike the Situation. No, okay. And
I'm from Jersey.
Oh, okay. And then I moved to law firm. I was working for Bird & Bird. It's an international law firm, but based in London, in fact, and any other countries, in 22, in fact. And then I moved to Maruta and Wspólnicy, the best Polish law firm ever. Okay, so this is a few start for me. Are there any coders in the house? Okay, we got some. Okay, are there any lawyers in the house? Whoa, so I must be careful. Okay, okay. My job to do is to focus your attention on a few things you should know before you start, probably, or maybe you start already, but there are not all the things, only the very specific. So I'm specializing in intellectual property, so I'm not doing a corporate law or let's say a real estate law or whatever. I'm doing IP. IP or in fact hard IP, it's software. So this is my job. So my job here is to focus your on IP stuff mainly. Not only, but mainly. I hope it's good for you. If not, I'm very sorry. So we can start. Mamy pilotację. Okay, okay. No nie musimy już. So this is the main question I asked it before, legal things you need to know before you start. Any of you running a startup? Just a few. Okay, so this is for us. Okay, do I really need a lawyer at all? Any of you ever hired a lawyer? 1, 2, 3, 4, 5, 6 ever. So it's not a, let's say, good result. It's a very good question because it's in fact very hard to ask. From my perspective, of course, yes, you do. But my perspective is a little bit biased because I'm a lawyer. But in fact, it's the very popular myth about lawyers that they are very expensive. They have, let's say, hourly rates, 100 euro per, okay, 100 euro per hour, or maybe 1,000 euro per hour, and so on, so on, so on. And there are myths. We are not as very expensive as it is in the public knowledge. So please, when you're writing your schedule, your Excel, please make a little space for the lawyer costs. We can talk about later. We can talk about later. I'm not saying it's a very crucial. I'm not saying it's the most important thing you should remember. But I'd like to say it's important. Probably, judging by my practice, when a startup or the companies like startup calling for a lawyer is usually too late. It's usually too late because the mess is all around. So have a lawyer at the very beginning. You can miss the mess. This is my message to you. We can talk about my rates or rates from my, let's say, law firm or law firm when I'm working, but not during my speech, because it would be very unethical. But we can talk about this a little bit later. So this is the first message I'd like to point to you. Think about lawyer. They are not so expensive as you think, probably. This is maybe the most important slide in my presentation. Get everything in writing. Everything. I'm not mean you should have a contract paper on a paper, but unless in email. Telephone conversation, SMS is, I can improve SMS. But always if you're doing a business, think in your mind, how can I prove it? When I stand and face the court, how can I prove it? That I really did something. By telling a judge, oh, we were having a telephone conversation and he said yes. Or he said no, whatever. It's totally bullshit. I'm not telling you that you should always go to notarius and having some kind of very expensive papers. But please use your email box, and have everything on an email box. Everything what is important, not some, let's say, blah, 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 and so not important stuff. But so business schedules, some, let's say, contracts, everything what you think might be important to prove at the further stage of your business. Maybe not at the very beginning, but maybe at the further stage. Because this is connected with the next slide, and the next slide is, what is the first rule of the due diligence? You know what the due diligence is? When an investor came to you and say, come on, I'd like to buy your business. I'd like to buy your business. You're doing good. You're a very talented guy. You got great business models. You got great energy. But first, show me your papers. Please show me your papers. Because my lawyers told me, tell them to show the papers. Because the papers are fucking important. Really. And using the papers, I not mean only the papers in fact, but also the emails, everything that can prove that you really did something. Especially if you are working in a software house, in a startups, and you are coders, when you're working with the intellectual property, the paper is very important. During my practice, I have one very tough negotiation, and we're going too far. We got to due diligence. On the table was 35 million zloty, and in fact there was a lack of 2 papers, of 2 contracts. And deal is not done because of this lack. So you can see how risky it is. Can you imagine 35 million zloty? And the lack of 2 contracts. The contracts was about intellectual property, and there was a contract with the staff. There's an employment contract with the coders of the code of the, let's say, service. And the lack of these documents put all the business down. So please have it in your mind. NDA. Anyone sign NDA ever? For what? What was the reason of NDA? Okay. Any other reasons? Okay. So you think NDA is important? Honestly speaking, I don't think so. Who cares about NDA? In fact, you cannot protect your idea. In fact, because idea is not protected by law. In Poland, in Europe, in fact. In USA, yes, but in Europe, no. So the idea, who cares about idea? The execution is the main thing. How to execute the idea, not how to protect the idea. I saw very, was maybe 6 or 7 during all my, let's say, career situation, when the startup guys were so much focused on the NDAs and negotiating the NDAs that they don't just forget about the real project. The negotiating of the ADA is the lack of, let's say, it's a waste of time. You don't have to do it. I know it sounds ridiculous because I'm a lawyer and I'm saying that NDA is fucking bullshit, but it's true. No one cares about NDA in Silicon Valley. No one. NDA is so... NDA what? For what? There is no document, there is no paper, there is no legal mechanism that can protect your idea. Right here in Poland or in fact in Europe. So don't bother. Don't waste your time. Focus on the project. Focus on your business. Focus on your investors. Focus on your, I don't know, on your intellectual property because this is my mecca. But NDA is not very important. This is my message to you, the second one. I guess, in fact, third one. Okay. But this is my recommendation. Should you patent your idea? Anyone of you think about that? Because in fact, the answer is very simple. Coders, I saw coders here. There are some coders here, right? Yeah, come on. In fact, in Poland and in the European Union, you cannot patent your idea, and even you cannot patent your code. So just put it in the waste bin or in the trash, whatever. You cannot do it. Code, intellectual property is not, as far computer programs, is not patentable in Europe. You cannot patent it. You can in United States, but not in Europe. So when you are starting your business, you are at the very beginning, don't focus much on patent your code. Because this is costly, first. And this is only possible in United States. So who cares at the very beginning? So the very simple question for that is, very simple answer for that is, no, you shouldn't. This is the greatest advice I can give you here, judging by my practice. How can I protect my idea? This is one message I'd like to point to you during this stage. If you'd like to protect your idea, execute it. Just make it done. This is the best way to protect your idea. Not any fucking NDAs, not patent. No, just execute it. Make it real. Because this is the best way to protect it. Should you register your trademark? Sometimes yes. Sometimes it's very useful if you have a nice and very catchy slogan, let's say Spotify or whatever. It's good to make a trademark because it's that no one can steal your domain name and can be very harmful. It's not very costly. It's about, let's say, 3,000 zlotys. I know it's not so big. 3,000 zlotys is not a little, but it's not so big. And it can be very helpful. So if you ask me, should I register your trademark? I said, yes, you should. Yes, I think you should. Where? When? When you are registered. Yeah, after. Yeah. No. Before it's a crime. Yeah, before it's a crime. So only after.
But I'm not asking about our side, I'm asking about trademark.
Yeah, this is exactly the same. This is exactly the same. So only after registration. Copyright's my favorite one. I'm in love in copyrights, in fact. And this is very tough love, but yeah. But when we talk about the startups and starting your own business and your own business models, and especially if you are coders or you are working in the software house or you are making a kind of video games or game business, the copyrights are the most important thing to you. Copyright, because copyright is your code, and your code is the most important thing, because this is your copyright, not a patent, not the NDA or whatever. Only copyright can protect you very useful, in a very useful way, because you don't need any registration to be protected by copyrights. Just write your code. You don't have to even finish it. Just write it. It's already protected. And you must know it. You must know it. Every code you probably every code you wrote is protected by copyright. Because I cannot imagine a code which is not protected, in fact. So this is your weapon. Copyrights, not patent law, not any other stuff we should I just show you. Copyrights, 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 copyrights. This should be your, let's say, I don't know. There's a very special word in Buddhism, it's called mantra. Copyright is your mantra. And copyright is a very specific one, because you can sell, you can buy copyrights, let's say for your code, let's say for your game, only using a paper, only using a paper agreement. So whenever anyone can tell you that, come on, I can buy your copyright by the email or SMS or any other conversation, this is bullshit. This is bullshit. You can sell or buy your copyrights only in paper, only in writing, only in writing. And this is crucial for you. I can hear you.
Electronic signature. Specifying electronic signature. If we are doing it, could be the...
Yeah, but only if the signature is classified.
Yeah. Well,
Yeah.
basically.
Yeah. So yeah, it would be something what would be seen as a as a legal. Yeah.
The paper agreement.
Exactly. Copyrights, probably the most dangerous thing when you're doing your startups. When the investors come to you and asking for the contracts, probably he's asking about contracts because he's looking for copyrights. You don't care about any other things. Don't care about your ideas, don't care about your, let's say, okay, business model is very crucial, but from the lawyer perspective, business model is bullshit, okay? What matters is copyrights. This is lawyer perspective. And you have to have it on paper. So please don't get in any kind of transaction without a paper. When it comes to copyright, the paper is highly required.
Could you just explain a little bit about who owns the copyright and the code?
Who owns?
Well, basically, you have a company, you have several different programmers
Yeah.
working on code. Without any agreement signed, where is that copyright
Yeah.
ownership?
The main and basic rule, the copyright belongs to author.
So whoever wrote it.
Whoever wrote it, yeah. But this is the rule. And we have, of course, we can obey the rule. So if you are running your startup and you have some kind of staff, let's say 3 or 4 coders, and the staff are working for you, based on employment contract. Not working for hire, because work for hire is umowa o dzieło, but on an employment contract. So if you have staff that working on an employment contract, all copyrights belong to you.
To the employer.
Yeah. This is worth remembering. Yeah. But this is one and only thing when the copyrights not belongs to author. And in fact, the same way they are produced, they go to employer. But only if the employment contract is only in case of employment contract. Only in this case, not in the case of working for hire or any other kind of civil obligation between you and your staff. Only employment contract. So the main rule, the copyrights belongs to author, but when you are running your business and you are employer and you got staff and you got employment contract, then it belongs to you.
So how can I get copyright to someone who coded for me and I invoiced him for that? And I have like
You must call your lawyer. Call your lawyer. This is the first thing you should do in this case, and ask him to prepare a very gentle clause of transmission of copyright from your staff to you.
so each time.
Yeah, each time. Yeah. Yeah. Of course, you can make it by the agreement that is in fact very, how to say it in a very proper English, because I get a little bit problem with that. My message is, when you have staff and the staff is not working based on an employment contract, be careful. Be careful on copyrights. Because employment contract is very easy as for copyrights, but how many of you working right now based on the employment contract? How many of you coders? Any of you have employment contracts? One. And the other? 2, 3, okay. It's a lot in fact. Because it's not very often that coders working on employment contract. It's usually working for hire. And when they are working for hire, let's say employer should be very careful about the copyrights and should take care that in their agreements should be a very specific provision about the copyrights, about the transmission copyrights from one to another.
Is it the same in the States or just in Europe?
In Europe. In Europe.
In the States, it's,
I don't know exactly how it works in States, but I'm sure it's not the same. Yeah. Because I'm not the lawyer from the USA. Hopefully or unfortunately, whatever. So I cannot speak I cannot confirm you that how it works in the United States. I don't know. I don't know in fact. But what I know, it's a different way than in Europe and in Poland. So this is the slide. This is the mantra. Yeah, this is the mantra. How can I protect my idea? Just execute it. Execute it. This is the best way of protection of your idea. Just make it real. Make it real. Then everything is much more simple. Staff employment is going to watch for copyrights. We just talk about a little about it. This is something we should have in your mind when you are running your business and you have staff, when you got employment, or if you are a coder. If you are a coder, it's also very important for you. Watch for copyright. Personal data protection. Any of you running a social network service or site or whatever? 1, 2, 3. Okay. If you're running some kind of social network, if you are going to be another Mark Zuckerberg or you are going to have another Facebook or Twitter or whatever, you must have on your mind the personal data protection things. If not, don't care much about it. Really. Only if you're doing a social network. It's important, of course, but it's not as important as in the social network service. I'm not telling you that personal data protection is something that you should, let's say, forget about. But it's not something that you must be very, let's say, Personal data protection can I think almost every, maybe not every, almost every lawyers in Warsaw, in Krakow, whatever, can make you a good personal data protection deals. But when you are running a social network sites, you need a very specific lawyer who is really specializing in it. So this is something that you should focus only when the social network is running.
One question here, because
Yeah.
very often when you have not a social network but any other portal, and usually when users register, they put their email addresses.
Yeah.
And you keep their email addresses. Sometimes it's name and surname, right?
Yeah, of course. It's personal data.
So is it personal data?
Yeah, of course.
For example, many people don't have a social network, they have e-commerce sites,
Yeah.
they have a blog where someone can register or put in comments. So should all of them actually think that email is a personal data and they should...
Email is personal data, and when you're running your e-commerce, you and also should have in your mind a personal data protection issues, but they are not the most important one. You can manage that by, let's say, reading a very helpful and very useful guide from the Giodo site. And the
They are very specific about emails because they, from what I remember, Giodo answered that emails may be a personal data or not, depending what's there, because someone can just say that, I don't know, Sam 53, right?
Okay. To make a long story short, email is personal data.
Yes?
Yeah. Of course, we can imagine a situation where it's not, but it's very tough to imagine. So for your practice, for your, let's say, for your help, you can assume that email is personal data.
So if we store it, we should go to Giodo and...
Yeah, but you can make it by the,
online.
yeah, you can make it online. It's very easy, really. It's very easy.
And do you know exactly what can happen to us if we don't? When someone goes, I don't know, goes to Giodo and says that we have his email and we do not give them the information about storing personal data. Is there something to be concerned about? They can just come and
I don't think so. I don't think so. I cannot say that I would not recommend it to make all the personal data protection things clear, but the risk of being controlled by Giodo, if you are not, let's say, Facebook, Twitter, it's almost impossible. It's almost impossible. In fact, this is all I have slides for you. If you have any question, you can shoot on me right now.
Okay, so I have three questions.
Yeah.
Okay, so the first one is something that I was wondering about because I'm creating a game for tablets and mobile devices, and
Yeah.
as we know there's a problem with patent trolls in USA,
Yeah.
where they have patented thousands of ideas, like clicking
Yeah,
on a
yeah,
button
yeah,
or
yeah.
something, and they are known
patent
for
freaks
actually
in the USA.
Threatening to sue single developers, even single developers, because they infringe their patents. And actually, when I have a company in Poland, for example, and I put my game to Apple Store and to, for example, Google Play. I will do it in a moment,
Okay.
actually. And I'm just wondering, because I was thinking that if I'm here in Poland, so my law, I mean, this is law from the United States, so I should not be afraid about them suing me. But I read on one of the sites that actually if I make my product available in the United States, for example, and my game will be available in the United States, then they have the right there to sue me. I'm just wondering if it's something to be concerned about at all, that I can get this, I don't know.
My question is if you, when you were coding, did you use any of codes belongs to Apple, Google, or whatever?
No, actually, I've written my code myself, but...
So you don't have to be worried about anything.
Well, I'm not really sure because I know some developers from the Valley and so on where they were asked to sign they have a button that after clicking send them to their site, for example. It infringes one of the patents.
Yeah.
And so on. It's true.
If the code is yours, Okay, this is a good question. If you like to run your company and you are focused on the coding, it's good to have lawyer on board and have some kind of patent check. You are making a patent check
Let's say that
before.
that I do infringe. Okay, I just want this example. I do infringe patents. I mean,
So
some
you're-
of the patents.
yeah.
Okay, so what can they do to me? I mean, can they actually do something at all to me as long as I'm in Poland? For example?
Yeah, they can break your neck. Yeah, in
They can
fact.
send someone with knife.
No, they can send someone with the papers and the lawyers from the very, very known law firms from the United States and make your situation very poor because you used their intellectual property, and they are, in fact, they are crazy about intellectual property, especially Apple. Apple is crazy about it, believe me. I have 2 or 3, maybe not very funny. In fact, was okay. Funny is not the most proper word. A very specific situation. 3. I cannot speak much about it, but it was a very known company from the Cupertino, and a very known company from Cupertino is really freak about intellectual property. And you cannot imagine what they can, how many they can do to make you sorry for using their intellectual property. Even though it's no matter, it's really no matter. It's just it's just a matter of costs, and costs for the firms like. Who cares about the costs?
Okay. And the second question is about registering trademarks. For example,
Yeah.
let's say that I have a internet portal, let's say it's a social network that is working for like more than 10 years. It has got this, let's say that, let's think of something, I don't know, it's Green Sun, for example, .pl. Let's say that I have it. It's been running for 10 years. It's got a logo that I created 10 years ago, and I have never registered it. And let's say that right now, till now, nothing happened. Nothing wrong happened with it. And I'm just wondering, is there a situation that something can do to me to steal it from me by, I don't know, registering? Because from what I learned by reading internet, so actually it's very poor knowledge, is that as long as I actually can actually prove it, that I have already had this name for like 10 years and it had this logo, then no one should be allowed to register it right now. So actually, I do not have to worry that much. I mean, so this is my question actually. Should I actually go and register it right now?
Yes,
If
you should.
not, so what can happen?
Yes, you should.
Okay, I should. So what can happen to me if I don't?
I can steal it from you. And how you prove it? How you prove it? That okay, you were using it for the, let's say 5 years or 7 years ago. Yeah.
It's been online.
It's been online. Okay.
Web archives, every Google cache, everything has got 10 years of.
But you did not make any kind of registry in the patent office.
No,
Yeah.
just registrar. Just I have got this domain by.
Okay.
Right?
But this is not some kind of trademark or whatever. You don't have any kind of registry law. Okay. I can. It's not even stealing, because if you did not care about registration for 7 years, this is only your fault.
So about the copyrights. When he created this logo or which he had copyrights.
Okay, but this is the question: if the logo is a graphic sign or a literal sign. When it's the graphic sign, okay, copyright is the issue. When it's only let's say a literal sign, it's not the issue. But this is not stealing. This is not stealing. And from the very practice perspective, I can always recommend you that, okay, if you are running your business and you think that your let's say name or trade name may be important for you, don't waste your time and go to the patent office and make a trademark. Because it's not very costly and it could be very helpful on a very, very, very further stage. because someone can steal it, but this is not stealing in fact.
Well, actually, but very practical question.
Yeah.
I have a domain name. It's called, let's say, houses for. No, okay. Let's say something that I think of. So let's say,
Okay, so
Macumba. Okay, let's say Macumba. Whatever.
tomorrow I will.
Oh,
Okay.
Okay, so, and I have this domain for myself. I mean, I bought it, so it's mine. And is it possible that you can go, register this name, macumba.pl, even though you do not own the domain? You just go there and say that macumba.pl is my trademark, and then you sue me in the court because I am using something that belongs
Yeah,
to you.
it's yeah. I can imagine that. I can imagine that.
Someone like this would be.
I think maybe it's not very possible, but it still it is.
Okay, but it's not 100%.
No, nothing is 100%. Besides, the taxes and the okay, but it's possible, but very hardly, but still. So really, don't waste your time. And you were talking about house or greenhouse or whatever. What was the what was the name? Because I can write it down right now and make a short
I
registration.
have about 12 domains, so it will cost me like, I don't know, 40,000 zlotys, you say, for each of these domain names to register, to the trademark. It's quite a lot of money. I'm not sure if I really want to do this. I mean, I don't have...
It's always a kind of business calculation. It's a business calculation. So you pick the most important one and go run into the patent office and make it register.
Okay, and the third question...
This is my advice.
Okay, thanks. I would definitely think about it. And the third question, the short one is, what is your opinion on this new cookie law that requires all of us to break our sites and display this stupid sign about this site uses cookies?
What is my opinion about that? Really? You really know? My opinion is very simple.
Okay, so I'm just wondering what can happen, because I don't know if there's any precedent even in Europe.
Anything can happen. Even you can be fined by what was the name in Urząd Regulacji by UKE. UKE is a very specific office in Poland, and they can fine you by 10% of your last year income. Yeah. So this is hypothetically it's possible. It's 1% chance, but still it is, and this is why. I know this. We are recorded, so it's very hard to say what is my real opinion about cookies. But cookies is not the smartest idea we can figure out.
But I read that it's not necessary to create a sign and inform the user of the site, but it's only necessary to take in the menu note about it. You have to click it, and there is a note that you are using cookies and so on.
Okay, I didn't know this theory, but maybe it's possible. Maybe it's possible. My position is to put on a short or very user-friendly disclaimer, and you can sleep well. In the other thing, anything can happen. Anything can happen, really, because this law is not the smartest one. Let's say in a very gentle way.
I can add something on cookies. But things can happen depending on your market, depending on the country. For instance, last week in Spain, we had a case, and it was the first fine, 60,000 euros for a regular guy who owned a website and didn't implement the new European directive.
Yeah, but the funny thing was that he actually had a sign. He said that, but he was setting the cookies. For example, Google Analytics and other stuff.
Yeah.
They set the cookies. So he set the cookies like every one of us do, even though the sign was there. So he was fined not because of the lack of sign, but because he was setting cookies before someone accepted. So and actually, probably 99% of the sites in Europe show the sign, but set the cookies anyway. Exit the site.
It's ridiculous, but
That's why I decided to
Or
work
here in Poland. In Spain, it's because it was implemented in a different way, and it's the only exception. You have to express accept it before they send it, but not in Poland.
Okay, so in Poland it's
In
not
Poland,
like
it's
that?
fine.
Oh,
You're
okay.
safe.
Oh, that's good information. Okay, so
Can I just ask about the cookies, where, what does it depend on as far as where the site is hosted, where the company is registered, or where the site is being viewed?
Where the company is registered.
Where the company is
Yeah.
registered. So say if the company's in the States,
Yeah.
hosts the site in the States, but makes the site available in Polish, and the users use it from Poland, then you don't need to have that.
No.
I have a remark on that question.
Yeah.
Because I actually also do copyright more to kind of
Creative Commons, yeah. I just a short interruption. Creative Commons was the first project I made after my study. I was translating a Creative Commons license. I was working with Mr. Larry Lessig. It was very honor for me. It's honor for me to work with this guy, and we were translating the Creative Commons license to Polish language. Then I was working to MTV Networks, so at the other side of the barricade. But okay, this was just a short interruption.
Copyright is really a mess. For the last year, I've been working with institutions of culture that have really messy copyright because they have volunteers, they have all different kind of contracts inside, they sign all different types of agreements because somebody, sometimes they do a photograph that has its own and they just sign because they don't know. But once you learn how to read those agreements and how to construct them, we have a lawyer who will write this draft agreement for you. Actually, you won't need a lawyer afterwards if nothing bad happens, because if it's all straightened up and you know what it is and you know how to read those, you won't have any problems at all at any point, probably, because you always can. So, if you think it's a lot of money, it really isn't. It's a bit of a change in procedure, but even if with a really small budget, like the NGOs or such institutions I work with, it's really possible because it's just a change, just understanding how it works, and afterwards it's there's an easy hike, mostly.
Yes, yes, I can admit that. Even I'm a lawyer, but I can admit that. Yeah. It's fact. It's very easy to make a very readable and simple contract or agreement to read, not for lawyers, just for a single person. I'm not talking about a very complicated one, but let's say agreement for NGOs or something.
If an NGO that has
Yeah.
3 people working in it can deal with it, we probably also can.
Yeah. Any other questions for me? Okay.
you thought that the best way to protect an idea is to execute it, but as long as I'm not a programmer,
Yeah.
I cannot execute it. How?
Yeah. In fact, you can hire a programmer.
Okay.
For coder.
Let's say, and
Remember this is a very important one. The functionality is not protected. You cannot protect the functionality. Code is protected. Functionality is not. I know it's a problem. I know this is a very surprised one, but functionality is not protected. You cannot say, "Oh, come on, this is my functionality. This was my, say, business model. This is my, okay, this is my emotionally." But from the legal perspective, this. It must some kind of material, let's say, material structure. Then you can copyright it. Then, idea doesn't have a kind of material structure. Idea is just idea. It's just a string of your business and add other ideas to make a great money. Yeah. You can just copy their functionality, maybe not one by one, but almost the same. Really. If you are not using their code. Because when you start using their code, you got problems. So this is why the code is very important. The code is crucial. The business model and the algorithm of the business model, the idea, especially in Poland, especially in European Union, is very hard to protect the idea. The idea is from the, let's say, basic, from the very beginning of copyright law in Poland or all over the Europe. The idea is not protected.
What would be your advice to a situation like this? I was employed some time ago on an employment contract. I wrote a framework and some additional functionality that was specific to the company that I work for. Now, according to what you're saying, that all that code belongs to the employer. Now, the framework is sort of a universal thing. It's not specific to that particular thing. It could be used for anything. Now, if I would want to take that code, that framework, and publish it open source, how would I go about, say, communicating with the employer, for that company? Because the code is actually his, right?
Yeah.
He doesn't really understand what the difference, where the framework ends and his solution begins. But
if the code you wrote is copyrightable, let's say, if the code you wrote is
what is copyrightable? What does that mean exactly?
I mean,
The code is copyrightable.
yeah, almost 91% is.
Right.
Yeah.
Something that's written from scratch.
Yeah.
Not taken from anywhere else.
Yeah, okay. So we can assume that is your code is, sorry. And you had an employment agreement with this guy. Of course, it depends on what were the provisions of your employment agreements, and very specific. Are there any specific issues about intellectual property in your employment agreement? You don't remember. So before my recommendation, I should look at your employment contract. But if you ask me just like that on a Hive, I would say that the code is the guy, he's the owner. So if you'd like to spread your let's say, code to every one of us, you should get the permission from this guy. Unfortunately.
Right. And how far, as far as the geographical locations, that goes? Like, because when we're talking about Poland, we're talking about European Union.
Yeah.
But I operate outside of the EU.
Yeah.
So does that make a difference?
Just have to call your lawyer.
It doesn't make a very difference because the thing, the basically thing in this situation is the contract between you and this guy. This is the very distinguished one in this very specific case. So this is the obligation between you and this guy, and I don't care much about a multi-international stuff or whatever. The guy is from Poland, or I don't know, his company is registered in Poland. You are a Polish guy, yeah? You are from Poland, or let's say okay. But this guy it is, yeah. The company it is.
So basically, I just need to make an agreement with him.
Yeah.
For
Yeah.
in writing.
Yeah. You can make a very simple license agreement. I can write it to you. Really, it's not very difficult, but it can be very useful for you. Yeah, you can avoid problems.
My question is, how about algorithms? Because we are talking about ideas, functionalities on one hand, and on the other hand we are talking about code, which is very specific.
Yeah.
And how about some solutions, like way to deal with some problems or to implement something better. And for instance, one employee would implement it like for me, and then he would change a firm and he would implement the same idea. Sure, it would be different code, but it would be the same.
The same model.
Yes, something like that. Same algorithm, same solution.
So, the same makes a long story short. Poland, the European Union, the business models, the algorithm models are not patentable. But in the United States, they are. So it depends on what your business is. If you decide to running your business in the European, you cannot do it much, in fact. But if you decide to run in your business in the United States, you can have a patent for this. It's not very easy, but still you can. Any other question? Please shoot me, because the time is running down. I'm so fucking nervous that you cannot imagine.
Okay, so one last question.
Yeah.
The second last question for me. Okay, so from what I remember, when you buy a copyright,
Yeah.
then you need
Copyright, my favorite. Okay.
with fields of use, fields of exploitation.
Yeah.
So if you do not have them, then you actually cannot do anything with your copyright.
Exactly right. You're talking like a lawyer. You're talking like a lawyer. Yeah. Fields of exploitation is the very crucial provision of the copyright agreement or copyright contracts. Fields of exploitation is everything, in fact. Fields of exploitation is what I can really do with the code or with the, let's say, movie or with the image, whatever. The field of exploitation. If you sign an agreement of copyright contract, whatever, of course, in a paper, because only paper works. Of course, only. Remember, this is the mantra. Copyright contract, if you'd like to buy or sell your copyright, it must be in paper. And you forget about field of exploitation. Just forget. You remember about the paper, but you forget about field of exploitation. All the contract is bullshit. Yeah.
How about, for example, you have a portal and you are uploading pictures?
Yeah.
So who has the rights?
When you have a service and someone uploading a picture, it depends of the regulation you had on the service.
Yeah, but you don't have a contract.
But this is a very, very gentle difference between selling or buying a copyright or make a license. If you're buying or selling a copyright, just like buying or selling a car, do it on the paper, because any other way is illegal, let's say. But if you'd like to grant a license, especially a license which is non-inclusive, yeah, you can make it by phone, by SMS, by email, by whatever. But license is not selling or buying a copyright. License is just a permission to use. This is license. Permission to use, but only in a very specific time. This is license. So there is a point in time when all the laws back to you. And when you're saying or buying a copyright, you're just saying and buying once and forever.
You can move this right to the other person?
I mean license.
I mean, for example, you uploaded a picture, it's your picture.
Yeah.
And then someone else wants to use it.
Probably the 99.99% of the service, which is uploading and downloading an image, is nothing, just an infringement of copyright. Let's say Pinterest. Pinterest is a very specific example of infringing of copyrights, but it's not my theory. It's what I've just read in the paper. In TechCrunch, or I don't know, I don't remember, but it's a very famous one, blog service. But if you let's imagine if you upload an image on a Facebook. The things you do is just granting a license to Facebook. Base it on the regulation Facebook has. But no one reads the regulation. This is the problem. No one. I've read 2 times because I have some legal issues and I need to do it. But it is not very easy. And it's, let's say, 30 pages in fact.
But still, copyrights are for the someone who uploaded the picture.
Yeah.
So copyrights can only be on the one entity. I mean, can I just grant you, for example, copyrights and on all fields of exploitation, but keep it still?
No.
So only one person, one entity can hold the copyright.
No, we can.
License to others.
Yeah, exactly. This is what you should remember, especially if you are coding or you are running a business, let's say software house. There are always 2 options. You can sell it, I mean your copyright, or you can license it. The license is always the best one, in fact, because the copyrights are still yours, but only for the very specific time they are moved to another entity, but only for the very specific time on the very specific fields of exploitation. And when the time comes, all the backs to you.
Always have to be time limited,
Yeah, always.
but you can make it 100 years.
Why not?
What about
But remember, you must point in the license agreement the time lapse, the time period. Because if you're not, the copyright bill, Polish copyright bill, says that if you are not doing anything like it in your license, the license is granted for the 5 years. Only for the 5 years.
What about corporate software, where you make continue working on certain software under a certain license that you got for the software, develop it further, and then you have this mishmash of everything. Nobody really knows who belongs to what anymore.
Yeah.
What happens?
I don't know what happened. I know what happened. It may happen a very problem. It may be very problematic. It might be very problematic. And if you would be my client, I would suggest to make if you'd like to get into this mess when no one knows who are the owner of the copyrights, let's make a simple due diligence and make it clear. Make it clear first, and then make any kind of agreements. This will be my recommendation.
But don't you think that there is a possibility when you're actually coping with major players, and they are coming in with their lawyers, and the license will be as wide as it can get. And your actually law, time period will be like 50 years, and the law anything to do with that particular program or code or anything would be so similar to ownership of the law, actually, especially to get profits of it.
Yeah, you got right. License, especially when you get license which is very wide for, let's say, 100 years in all fields of exploitation. You know, it's almost like selling your copyright, but it's still time period. It's still time period.
Your grandchildren can use it too.
For example.
In this case,
Yeah. This is a very business negotiating situation. If we're selling our rights or we make a license, so it's very business thing. It's a very business thing.
They just come in and they make a list of fields of exploitation, and they can expand it to, I don't know, to the next galaxy, for example. They can, believe me.
Yeah,
And if
I
the
believe
wish
you.
of their client is to be next galaxy and fix so on, they will do it.
Yes, I can imagine that, but you know, everything is possible in the agreement. Agreement can hold everything, you know. I don't know if judge can, but agreement can hold everything.
Can be a license like that won't let you use the things for the other guys. Or the other license they can
Yeah. I didn't hear the second part of the question.
I mean, imagine that we upload it.
Yeah.
And this portal has somewhere the license agreement that says that no one else can use this picture.
Yeah.
Only them. Is doable?
Yeah, of course.
But the rights are on them.
It depends on your will. If you are okay with this in the license agreement.
Yeah, but how about what the owner then can do? Nothing? The owner of the copyright.
So you are talking about the situation where the owner of the copyrights cannot use their own photo, let's say.
Yeah, exactly.
It's imaginable. Yes.
Guys, maybe one more question.
There's still plenty of food left.
One thing. For the copyright, as I remember, not just the lawyer and copyright, they divide into personal rights and material rights, right?
Exactly.
And whether I'm like in the employment agreement, I should rather say that I take care of all I take on myself as an employer. All the rights of the employee to vote or anything. Whether I need to specify that he shall waive his right to show that he's the author. Right? Can I do it?
Yes, you can. Yeah, yes, you can.
Because if we think about the situation that we took her about the material rights, and we don't show him as an author, what will happen in this situation? Can he harm us and still make a claim on the basis of
Yes. It's possible, but in fact very hard to imagine, but it's still possible, because you can buy all the material copyright rights, or all fields of exploitation, okay, whatever. But personal copyrights are still with the author, and the author cannot sell it to you. It just cannot. They are very personal. They are very in author, and just and what is very important with the material rights and the personal rights, the material, it's only 17 years after your death of the author, let's say. And the personal copyrights are perpetual. So 100, 200, 300, 500 years, and they are still in life. So it's very dangerous. So if you are preparing an agreement with the coders, please be very careful on the provisions that are connected with personal copyrights. It could be very harmful for you as for employer, because you can be very happy, said, okay, I've just bought every material copyright I can. But remember, there's still personal issues. And they can raise a claim and go to jail.
It's something that can kill someone. Because I was actually having cases like a person who gave a photo, he signed off his material rights, though he did not sign the individual rights.
Yeah.
And he was signed off the authors of the photo, and it came public in some book or magazine, and he was saying, oh, this is my photo, and I should be there as
Yeah. This is based on the personal copyrights, and it's article number 16 in the Polish copyright law.
I don't know.
So every time you wrote, especially when you are a business guy and you are dealing with decoder, don't focus only on the material copyrights or your lawyers, because I don't assume that you are focused on it. It's your lawyers. It's also very important thing is personal, which are perpetual, so you cannot buy it, but you can make a very specific provision to be very, let's say, to avoid very specific kind of problems. Yeah. Exactly. Okay. So, let's go. That's it.